Good evening. On behalf of the New York Technology Council, I'm pleased to welcome you all to this event entitled Social Media Do's and Don'ts, Legal Compliance You Will Like. My name is Paul Ellis. I am a board member of NYTEC. I run the legal track of events, of which this is one. And when I'm not doing NYTEC events, I am the principal of the Paul Ellis Law Group, a 5-lawyer firm that does work with small and mid-sized technology companies in areas including formation, angel and VC finance, intellectual property protection, licensing, and exits. So very briefly, I want to thank the sponsors of NYTEC. I won't go through all of them, but these are our 2012 sponsors. We depend upon their support to make events like this possible. I also want to especially thank EisnerAmper, which is one of our platinum sponsors, but also providing the space this evening. For those who are not aware, EisnerAmper is an accounting firm that has deep expertise in the technology industry. They've been a great support to NYTEC over the years, and I want to hand it off to Mike Lopez to say a couple words.
Thank you, Paul. That was a very nice introduction, so I really don't need to say too much other than as a fairly large regional firm, we have decided to make a huge investment in the emerging technology space, and we're very happy that we're doing that because I can tell you, I've been doing this for a long time, and I've never been more excited, and I tell everybody this when I meet them, I've never been more excited to be involved in the emerging tech sector. It's absolutely white hot. There's just so many great young companies that are springing up, and we're all happy to see you here tonight. We hope that your involvement in New York Technology Council will continue, and you'll continue to learn from the great programs that we put on. And again, I'd just like to welcome you all on behalf of everyone here at EisnerAmper. We're very happy to host these events, and I'll turn it back over to Paul. Thank you.
Thank you, Mike, and I do promise there will be some content at the end of all these preliminary remarks. I really want to thank the law firm of Frankfurt Kurnit, which has spearheaded this event. Frankfurt Kurnit has deep expertise, as you will hear this evening, in this space and generally in digital media and new media, as well as many other areas. We're very pleased in particular to have as our moderator Glen Westerback, who is an attorney at Frankfurt Kurnit, where he counsels clients on software, e-commerce, and internet issues, including matters related to e-commerce, privacy and data security, blogging and social networking, cloud computing, online advertising, and the development and licensing of websites, mobile apps, and other software and leading-edge innovations. Glen also helps companies organize and reorganize and structure entrepreneurial ventures. He's the editor of cyberlawcurrents.com, a blog about the intersection of digital commerce and the law. We're very pleased to have Glen as our moderator, and with that, I will turn it over to you.
Thank you. Thank you, Paul. Thank you to NYTEC as well for the invitation to speak here today. It seems like only yesterday that we were doing our event on mobile apps. Also, thank you very much to today's panelists, who I will allow them all to give you a brief introduction in a few moments. But first, I thought we'd set the stage with some interesting recent statistics about social media. I think everyone knows that social media is enormous, but just how enormous changes every day. So here's just a few interesting recent statistics that I found. There are now over 2.8 billion social media profiles, representing half of all internet users worldwide. Facebook alone is slated to grow to 1 billion members by August of this year. 61% of the top 100 brands of Interbrand are now signed up to Google+. Social network started last year. And every 60 seconds, over 1,000 visitors access Pinterest. 7,600 searches are made on LinkedIn. 175,000 tweets are posted on Twitter. 700,000 Facebook messages are sent, and 2 million videos are viewed on YouTube. So clearly, with statistics like these, social media sites are important and useful platforms for marketing and advertising. They're where the consumers are, and increasingly marketers are using social media to share news about their products and services through advertisements, through promotions, and other means. But marketing campaigns using social media unavoidably involve various third parties, including consumers, social media outlets, marketing affiliates, and potentially others. So marketers need to be cognizant of the legal issues raised by the involvement of these third parties, and need to take care to structure their campaigns properly in order to fully realize the potential of social media marketing without leaving themselves vulnerable. So I thought we would have tonight's presentation go in roughly the following way. First, I'll allow each of the panelists to introduce themselves, with a quick introduction about what they do and their background. Then Michael Schiffer from Frankfurt Kurnit is going to give a brief presentation on endorsements 101 in the social media world, and then we'll have a moderated discussion with the whole panel. And if you could save audience questions for the end, we'll leave 15 or 20 minutes at the end for that. So with that, why don't we go down the panel here. Michael, if you could introduce yourself first, and then we'll just go down the line.
Hi, I'm Michael Schiffer. I'm a colleague of Glen's, and I'm a member of the Advertising and Media Group at Frankfurt Kurnit. We help brands, agencies, advertisers, bloggers, talent get their message out there, get their advertising content out there, and more lately we've been helping clients in the social media realm, whether their campaign involves an aspect of Facebook, of Twitter, whatever they want to do, we're helping them navigate the legal landscape, and I'm going to get more into that in a little bit.
Thanks. Hi, I'm Howard Greenstein. I'm the president of the Harbrooke Group. We help companies understand and adopt new technologies that let them communicate more effectively with their customers. What that effectively means for me is I do a lot of advising, training, and strategy and implementation of social media and other marketing technologies for everything from small companies to large organizations. I've done work with several large nonprofits as well. In my spare time, I teach a class called The Wired Nonprofit, which is social media for nonprofits in the master's program in the Masters of Philanthropy and Fundraising at NYU. And I write a column for Inc. magazine called the Startup Toolkit, which is information that helps startups better manage, market, sell, promote, and run their companies. And I also blog myself. I've been a blogger for about 10 years, and so I'm sometimes the subject of these outreaches, pitches, and stuff, and I'll represent that point of view a little bit in the panel as well.
Hi, Wade League. I am in-house counsel at Sony Music Entertainment. One of my duties is to monitor our company's use of social media, both set policy in that regard and also provide advice on various campaigns and employee questions about what they can and can't do in the social media space. And as we'll get into as we discuss it, obviously Sony Music is very active in the social media space with their various projects.
Hi, I'm Jake Feldman. I am a senior trademark counsel at Johnson & Johnson. So my day job is actually a trademark attorney. And because we care a lot about brands and what's happening to our brands, they thought that our group would be a good place to sit some legal counseling on social media issues. So I've been doing this for a number of years now. I helped Johnson & Johnson draft an internal social media policy, which was already outdated the day that it launched, and we're already working on another revision, which is already outdated and hasn't even launched yet. And everything that I say here is just, by the way, my own opinion, not anything to do with Johnson & Johnson. But I hope to bring an interesting perspective because I'm a very regulated industry. We have not only the FTC, which I think we're going to start out with, but we also have the FDA. And we have to worry about adverse event reports and all kinds of interesting things and twists that the FDA brings without any guidance to the table. So, or with limited guidance, I would say. So I'm really looking forward to the discussion.
I'm adding my Sony Music waiver as well. I'm speaking only for myself.
I'll speak only for myself and not for my clients, or the university, or the magazine,
I won't even
or my kids.
I'll speak on behalf of Howard.
Now I've got to pay him.
Okay, Michael, the floor is yours.
Okay, so my task here is just to give you some background about endorsements in general and give a couple examples of how companies and bloggers have gotten in trouble in this new social media world. And one thing I wanted to note as we move ahead for the rest of the evening is that when you have technology and the law, the problem with the law is it's always about 9 steps behind where the technology is, and it never seems to catch up. So a lot of what we're going to talk about today, yes, there's some established cases and some established framework on how to look at these things, but there's also a lot of guesswork and anticipation of where the law is going to go next and where the court's next going to interpret where it should go. Facebook's been around for 6 years already, but there's new cases every day that come up. That how do we deal with this issue? How do we deal with sponsored ads? How do we deal with anything new? So the landscape is continually changing. Taking a step back from social media first, and really from endorsements, as advertisers and agencies and anyone giving a message, the thing you have to be aware of is that you need to make sure all your ads are in compliance with the Section 5 of the FTC Act, which essentially says prohibits unfair or deceptive acts or practices. So in the endorsement context, the question is whether the use of the celebrity or the use of your endorser or the use of your blogger is somehow deceptive to your viewing audience. And so what's an endorsement? And lucky for us, the FTC put out endorsement guidelines to help us figure out what an endorsement is. And you can read the slide here, but an endorsement is, an advertising message that consumers are likely to believe represents the opinions, beliefs, findings, or experiences of a party other than the sponsoring advertiser. So this is from the endorsement guidelines, which I should note are advisory only. These aren't laws, but they are really influential, and they give you a sense of where the FTC is focusing its thrust of its litigation focus. But I guess to take a step back also, why do companies want to use endorsements anyway? And it really, the point is really highlighted when you think about regular people that are used in advertisements. I can, if I see Kim Kardashian make a post on Twitter, make a tweet about, hey, you should go to Banana Republic and buy a pair of khakis, I realize that Kim Kardashian's a corporate shill and I don't really believe anything that she says. But if I see on my friend's Facebook page, hey, I bought these pants at Banana Republic and they're great, then I sort of give that a little more weight. And that's why these companies are getting more and more into social media. They want to make use of friends and other people's comments and see if they can get any sort of advertising bang from their buck out of it. And when we're talking about endorsements, we're really talking about material connections. Your audience needs to understand from whom the advertising message is coming from. If they understand that inherently, then you don't have a problem. If they understand that, oh, that person was probably paid to say that, or that person has some sort of connection to the advertiser, then a disclosure isn't required and your message is probably fine. The problems arise where it's unclear that there is some sort of material connection between the advertiser and the endorser. So, this is how you get in trouble in the simplest context.
Sony Pictures is a separate company from Sony Music.
In no way related to Sony Music. And this was
related.
In no way related. So this was in 2002, I'm sure a long time ago. But what happened in this case was, you've seen these ads, they show people coming out of the movie theater saying, and this is for The Patriot, saying, oh, this movie was the best movie I've ever seen. I'd go see it again. I'd recommend it to all my friends. And that's all really compelling, it's a compelling commercial. The problem here, what Sony did is they had their employees be the ones that made all those statements. And they did not disclose in that ad that those were employees. So while those reactions might have been truthful, accurate, substantiated, real consumer opinions, it was really material to the consumers to know that, hey, that person was actually employed by Sony, so they might have been incentivized to say something positive about the movie. So that's where Sony got in some trouble there. So where does this take us in the social media world? Lifestyle Lift was a company that provides some sort of less invasive facial facelift. And what they did, their CEO was concerned that there was a bunch of information out in the blogosphere saying how poorly their service was working, that people were unhappy with their facelifts. So what he did was essentially send out, this actually was an email, I think, in the discovery phase of the case. He actually had employees from his company go out and make fake reviews about the company, how well their facelifts turned out. They set up separate websites that were supposed to look like they came from consumers, saying how great their experience was with the facelift, and it was all false. You know, this is not a good idea and something the Attorney General often does not look kindly upon, and there was a $300,000 fine in this case. In a similar scenario, Reverb was actually an agency for a video game publisher, and what it did was post some reviews on iTunes about how great a video game was. Amazing new game, one of the best, those sorts of comments, but they didn't disclose that they were the advertising agency for the video game producer. And again, they got into some trouble. So you have the advertiser and you have an agency, they're getting in trouble for doing these sorts of things. And then you have Ann Taylor. What they did is they invited a whole bunch of bloggers to come to an in-store event and said, if you go home and you blog about it, we'll give you a $500 gift certificate. Many of the bloggers, when they blogged about it, did not disclose that, hey, I got a $500 gift certificate for blogging about this. And, you know, Ann Taylor had actually taken some measures to guard against this. They had a big billboard at the event saying, hey, if you go home and blog about this, be sure to disclose that you're getting a gift card. But they didn't really follow up, and they didn't really care what the bloggers did. In this case, the FTC Act, you know, did not take any action against Ann Taylor, partly because this was right after the new endorsement guidelines came out in 2009. But it served as notice to the industry that these are the types of things you have to be worrying about. Now this case is where we start getting into more trouble. So we've seen that advertisers can get into trouble for not disclosing the connection, agencies, bloggers can get in trouble. Here, what about the situation where you didn't specifically tell anyone to say anything about your product, but this false word gets out there? And that's what happened in this case. I'm just going to say ERSP, they're a industry self-regulatory body. But what happened here, and HCG is a liquid diet form, pill or something like that. But what happened here was this person named Jessica Stewart, who had no affiliation with the company and apparently had nothing better to do with her time, was combing the internet looking for posts about HCG. And one of those posts happened to be, I lost 14 pounds in 2 days. All these other ridiculous claims, and she would tweet them from her own personal Twitter account. HCG claimed they had no idea she was doing this, and they were not responsible. They claimed they were not responsible for the tweet. But what ERSP found is that it doesn't matter that you didn't know this was out there. You are responsible for everything that's out there in the social media and the blogosphere about your company. You should be going out there and monitoring it. Now, maybe this case comes out differently if HCG on their website did not have a Facebook icon or a Twitter, hey, tweet about us. Maybe it comes out differently, but this case scared a lot of advertisers, and it still does. Now, I'm sure we're going to get into this a little bit more in the panel, but how do you disclose this connection between the advertiser and the endorser? In a tweet, it's not always so easy. You only have 140 characters. Is there one simple way that a blogger can do it in every situation? I'm sure Howard will talk about this, but it's different in every situation. It depends on what exactly you've received, what your material connection is, and what exactly you're saying about the product. But one thing to keep in mind in this context is that we're only talking about when endorsers make an endorsement-y type claim. If you say, Microsoft has the Microsoft Word program, that's not an endorsement. That's just a statement. That's not an endorsement. So all these disclosures would not be required. But when you're saying, Microsoft is the best company in the world, that's clearly an endorsement of the company, and you might need some additional disclosures for that sort of statement. And this is just another reminder that you know, it's not just the FTC, it's not just, you know, the FDA, it's not just every regulatory body, attorney generals, everyone wants to get into this game, but your biggest problem is going to be competitors, you know, whether it's other companies or other bloggers that notice what you're doing out there. And they're the ones who are going to bring the action to the regulators' attention, or they're going to bring it to your attention and bring a lawsuit. So, you know, a lot of companies and a lot of bloggers are getting away with not actually following proper procedures, but you don't want to be the one that ends up getting caught. And that's all I have for now.
Thank you, Michael. So why don't we start our panel investigating some of these issues raised by Michael's presentation. You know, the comment there about monitoring social media to see what others are saying online about your brand and your marks. How do you do that?
You guys want to start?
I'd actually like to start with the endorsement part, because while I was watching your slides, I'm wondering where we draw the line and where it starts. So, for example, you were talking about you know, if you're a Microsoft employee and you say Microsoft is wonderful, that obviously that's something maybe you have to disclose, right? But if you are, and this is something I guess I deal with all the time, and I bet you guys do too. We have you know, employees who are marketers, and they work on certain brands, and those brands have Facebook pages. So, you know, you sort of start at the basic level. Is the fact that I'm a marketer and I like my own my Facebook page an endorsement? How about sharing articles that are from that page? Do I need to say I work for that company? How about, you know, actually writing a comment about an article that you post on your own Facebook page? Where, you know, if it's a fact, do you need to disclose that you work for it? If it's an opinion, do you need to disclose that? These are things that I deal with on a daily basis, and I think we make judgment calls, but I think that the FTC guidelines are helpful, very helpful, because they actually spell out examples, and but I still think there's a lot of gray.
Yeah, I mean, I always tell people, be careful about setting a policy, because if you violate that policy, you've then created another problem for yourself. So when you're setting your policy, I think it's really important, obviously, to take all this into consideration and try to address it, but also to take the reality of your workplace into consideration. And, you know, not just on this issue, there are times when a company from a regulatory perspective may be in a better position to not have taken too hard of a line in a policy that they're deviating from. But we generally tell our employees that with respect to their personal social media, if they're going to be tweeting, Facebooking, whatever about our artists and our projects, that they need disclosure on the page that they work for Sony Music. That we've really stressed that, in part because sort of what we ended with there, we are obviously, I made a joke about Sony Pictures, but we're obviously guided as a sister Sony company by that experience. And we also have had our own experiences with the FTC, which one of my former colleagues is here who helped out a lot with that. And I can tell you those investigations and the process are very expensive and no fun. You know, so I'm given that, and that was only a little over 3 years ago that we reached a consent decree with the FTC regarding online privacy practices with respect to children. And I'll say straight out that it was found that we were not marketing or targeting children. We just had some trouble with our age screeners at that point in time. But it guides my thinking and our thinking in terms of what we tell people. That being said, I know everyone's very active in social media, so we try quite often to send around certain reminders, you know, friendly reminders of, hey, here's some things to think about, including, I try to draw, without getting too specific, actual things I've heard about in the company that have happened. You know, because one of your troubles, I'll stop in a minute, but I get started it. Anyway, one of the things we run into, separate and apart from endorsement problems and disclosure problems, you also have to keep your employees in check in terms of things they're sharing that they shouldn't be sharing. And that's a thing we've run into. For example, some excited intern posting something about a decision that's been made about an artist's upcoming project when the artist's management has not been told that that's the direction we're considering going. Let's just say I used that as an example in one of my communications.
So, as the non-lawyer, so don't take my advice as legal advice. As a non-lawyer, I would expect that somebody whose Facebook page I went to, who I knew worked for Company A, who liked a post by Company A, and who wrote a comment on a post for Company A, is, reasonably expected to do so because they work for Company A. And if it's on their Facebook profile or if it's on their Twitter profile, I personally have no problem with it. I know that there are various regulatory frameworks, and typically when I post something saying, I'll say client such and such, has a new thing coming out. So it's very clear that they're my client, just because I'm trying to sort of overcompensate. As an example, at South by Southwest this year, I was asked to do a panel by Samsung and to participate in their efforts regarding their program on the US Olympic genome. And they gave me this Galaxy Note, full disclosure, right? So on my webpage, on my blog, it says, at South by Southwest, I was shown and invited to support STAR, the Samsung US Olympic Genome Project. And if you follow the star down to the bottom of the page, it says, this post was created in connection with my appointment as an ambassador to the Samsung US Olympic Genome Project. This is a compensated position. So, it doesn't get any more clear than that. I got compensated for doing this. And I'm careful about doing that kind of stuff. Now, as a blogger, as somebody who's ostensibly an influencer and somebody who PR agencies reach out to on a regular basis to be part of their campaigns, I only take stuff on that I think is cool, that I think resonates with the audience that I work with, that I think makes sense for me. As I was saying to Michael, I wouldn't endorse diapers or baby wipes because my kids are in middle school and above right now, so I have no credibility in that area, and I couldn't tell you what's the good diaper or natural baby wipe these days, right? But there are mom bloggers I know who could give you an entire list of those things and be very credible about it because they're toting babies that they probably use those products with on a regular basis. And so, I think to Michael's point from his slides before, there's the credibility aspect, there's the disclosure aspect, and there's also there's some challenges from a social media implementation point of view. How do you, in 140 characters, say that this is sponsored? And one of the agencies that I work with makes you put #SPON on the back of your tweets. Of course, you have to make sure that that's 5 characters that you can't tweet. There's a firm, it's actually a New York-based firm, that's called Comply. For shortness, they're cmp.ly, but they can give you short links that link to a much longer compliance policy that gives your endorsement as part of your tweet, so that you don't have to put I'm endorsing blah, 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 because you've linked to something that says this person was compensated for and gives you a whole legal framework for it. So it's a nice, short, 7 or 8 character.
Have you found that has caught on, Comply?
I've seen some companies using it. I know that I know those guys. I have no direct connection with them other than knowing them from the tech industry. But I know that they're working with a bunch of different companies and brands and using those short codes for things.
But the user has to click on the link to see the full disclosure.
The user would have to click on the link to see the disclosure.
I wonder how an agency would look at that. I don't know. At least
well, I mean, but at 140 characters, again, I go back to the reasonable person.
Yeah.
Oh, yeah.
No, but I struggle with this in my personal life all the time. First of all, being a lawyer and anything you say sounding like legal advice, I self-censor all the time. And I try to use humor a little bit and say, like if I was posting an article that Johnson & Johnson had on his website or one of our brands or whatever, and to say, I may be biased because I work for J&J, but I thought this was really cool. So I try to sort of be light about it and, encourage my colleagues to do the same kind of thing.
Well, I was at the Grammys, and I was just so excited that Adele was winning as many awards as she was winning. And I heard in my head, this voice that I tell everybody what they have to do and everything. And I just couldn't help myself. And several work people are my friends on Facebook, so I just did it. But what I said was, I am so excited. Sony music artist, Adele, blah, 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 blah. And my page fully discloses I work for Sony Music. So I felt okay about that.
But do you think that everyone was going to go out and buy Adele's album because you endorsed it,
I don't
or
think
because she won a bunch of Grammys? I think some of this stuff gets.
No, that's right. But I can say, based upon experience, that I do think if an agency found a pattern of your employees posting just, I like this track, I like this album, I like this artist, and you had a consistent internal practice, it wouldn't matter what purchasing decisions were made.
And I think what I was saying before, how the law is always a few steps behind where the technology is, that's absolutely right. And as Jake said, the endorsement guidelines are helpful, but they don't tell us everything. They don't tell us, hey, when I say this on my Facebook page, this is exactly what I have to disclose, this is where I have to disclose it, these are the amount of times I have to disclose it. Every company is making its own decisions on what it's comfortable with, what it feels like what it feels like it's rational in the industry, and what it feels like it can get away with. If you just like a an advertiser's web page, is that really something that an agency is going to be concerned about? Probably not. Maybe your company is okay with that, but if you're making really detailed statements or claims about a product, especially a product that's governed by the FDA, then you got a lot more concerns.
Well, it depends also on are they keeping. It is part of it how many people have liked your site, and so can it seem like it's just these things that us lawyers play within our heads. That yes, sir, in isolation, a single individual employee liking one of our pages does not seem like an endorsement until you say, wow, you have 110,000 employees. If everybody liked it, that would make it seem like it's a very popular page.
And then when you tout, our company has X amount of likes, but 1/10 of those are company employees. Maybe that statement that you have this amount of likes is not as accurate.
Exactly. From a business point of view, if your employees don't like it, from my business point of view, if your employees don't like your Facebook page, you're doing something wrong, and you're not treating them right, and you probably are running a bad business. So from the flip side, if your employees don't like your page, I'm curious about your company. And I'm curious as a customer why your employees don't like your page.
There's another concept that informs how we approach this, a legal construct, which is consumer fraud laws in the various states. And it's funny, whenever I talk about these things, I always have to reference prior investigations. But we were also investigated several years ago by the New York Attorney General with respect to radio promotion practices. And see me later and I can tell you my thoughts about that. But one of the things that came out of that is this, at the time in the music industry, common practice of basically writing to your employees and say, hey, the single's out today, call the radio station and request it. And that was happening at that point in time. And having nothing to do with the underlying radio promotion aspect, that became apparent in the investigation. And obviously that was something that they weren't happy about. And so part of the agreement we have addresses that issue. And it's related because I believe if you were sending a lot of notes to your employees saying, come on, like our product, get out there, do it, you're creating a separate issue, separate and apart from the FTC issue.
No, and I think we think about all these things as such a new problem right now with social media, but on the flip side of that, this has been around for a while with the radio payola issue. You have DJs all the time, speaking in a character and talking about a product. It's always been somewhat sort of a confusion, at least to me, whether that's scripted or is this really from the heart? Are they being paid? Is it just part of their job? Those sorts of disclosures, advertisers have had to think about this stuff for decades.
All right, so we've been talking a lot about employees, but what about the consumers, the experts, and the organizations that are out there making endorsements in social media? Do you think that there's a different approach to monitoring them and to how they should be making disclosures?
Well, it's interesting, the case that Michael brought up of some third-party Twitterer endorsing a product and making claims about a product. And of course, because it's in a medical field, or I guess it's a pseudo-medical field, it's kind of tough to say. That's always a challenge for me. There was a woman who actually went off and started promoting a car company and trying to search engine optimize her own site for this car company, I guess to try to show, hey, I'm great at search engine optimization and I'm going to try to get a job with some agency, and the car company, and she was actually doing blogger outreach and telling people that she wanted them to write posts about a particular automobile. I don't remember the brand, so I don't want to embarrass that brand or anything like that. But, and she was offering $25 Amazon gift cards to bloggers and telling them to disclose it, that she was doing this. And she spent several $100s of her own money on gift cards to get people to write these posts and link back to this site. And the bloggers, a lot of them were furious and started complaining to that company and their agency. And the company and the agency both publicly said, we don't have anybody doing this kind of a program right now. We don't know who this is.
Wow.
And then they cease and desisted that person from doing this. And she got into a world of social media back and forth. But you know, these kinds of things, apparently they do happen. But I don't think it's reasonable.
But it was brought to their attention.
It was brought to their attention, and they disclaimed it.
They took action. Your case, though, what I have to think is she's doing these tweets, that she must be, the company must have its own Twitter handle, and she must be in her tweets using their Twitter handle.
Referencing them.
Referencing them, so that there, there's at least some kind of connection that they should have known, because they were, getting tweeted, if they were already.
Or at least they could check their feed.
Yeah, I don't know the case at all, but I have to assume there's something else, because just randomly, the internet is too big.
I'm going to tell you what I'm going to guess. I don't know the facts of the case. I'm going to guess there's an affiliate program, and that she could sell this product by having this particular code, and that every version of the product that she sold that came through her code, she got compensated for, and that's why she was tweeting about this product. I'm going to guess that that's a possibility.
There's another case where that came about. This case, I don't think that did happen, which would made it all the more what I think might be an outlier.
Exactly.
Where the company was responsible for what she did. But I think what it says is that companies now can, and to get to Glen's question, I think companies can hire agencies and different vendors that can comb the internet and scrape the internet and figure out where your mentions are. And I believe in this case, yes, there had to have been a mention of the company. HCG had to be mentioned in her tweet, which I believe it was. So they were capable of scraping Twitter to find the mentions of their company, but they didn't think it was necessary to do that.
Well, no, I mean, what I was thinking is they must have a Twitter handle and that she was using it. Or
maybe not.
I can't imagine, I don't even think the FDA has taken the position that you have an obligation to review the entire internet. I mean, there just can't
That's
possibly
impossible.
be
right. No,
if you already have an in-house program where you are otherwise scraping the internet, or you are becoming aware of these things and you choose to ignore it, then I could see that. But I have a very tough,
So then, to me, that's actually a problem, because as a person who advises companies on stuff, you're almost saying, well, if you're looking at some of the internet, you better look at all the internet. And if you miss something and you had a listening program, it's worse than if you weren't listening at all. And I have a significant problem with that.
Incentive,
because it's a disincentive to actually listen as a company from a marketing practice. And it's also, there are tools that are free, $100 a month, $600 a month, $10,000 a month, $100,000 a month, and up. Right, and depending on whether you're J&J or John's Candy Store, you're probably in the free versus the several $100,000 a month category. And the several $100,000 a month tools can tend to do a better job, keep longer histories of searches, give you more tools to interact with your consumers. Whereas the free tools and the couple $100 a month tools, have more limitations. So you may get 30,000 searches or 50,000 searches a month instead of the entire fire hose of everything that ever happened on Twitter. And that puts a big obligation on companies to say, if that's in fact the standard, you have to look for everything. That's a huge burden.
And that's exactly why big farm companies are struggling with social media listening.
Right.
Because if you are combing the internet and you come across an adverse event, which is somebody using one of your products and having a bad reaction to it, if you have certain elements, you are required to report that to the FDA. And so
and then you have to try to find that person, right?
And then even if you only have 2 of those 4 components, it's possible that you would at least make the effort to try to find the other 2 parts that you need to have a complete adverse event and find the person and help them and direct them to your 800 number or what have you. So it's absolutely overly burdensome if you're going to have a social listening program, which is why big pharma companies have been begging the FDA, and the FDA had promised and is delayed in giving better guidance on this front. Because that's why a lot of companies feel like their hands are tied.
So if I had an adverse effect of crying after listening to Adele, someone like you, would I have to call Wade?
Yeah, luckily we're not regulated on that front.
So that's why that case is very troubling.
Oh, I mean, well, keep in mind, it's not the FTC.
Right.
It's a self-regulatory body that came up with that decision. So, I mean, the industry is scared, but we'll see how much of a precedent it sets.
So if you're a company and you want to engage, you want a blogger who's influential in certain circles to post positive things about your brand or about your products. Before, in Howard, in your case, right? Samsung was pleased to have you make some postings on your blog, right? Because you're an expert in the field. Do you think that companies that approach various trendsetters online should say, well, we want you to post things about us, but they have to meet certain guidelines?
So from my personal standpoint, and Samsung did not do this. I mean, to be fully clear, they said, we want you to check out this program, and we offer you the ability to endorse it or not. And I didn't have to accept their gift or promote their program, and it's completely voluntary. And I actually signed an agreement with the agency that says, I have the ability to review it as I see fit. I have the ability, but if I do, I must disclose that I've been, a part of the program. And they gave me specific wording about disclosure, and the agency, Weber Shandwick, was very clear about how to disclose, so that they were covering, and I had to sign it. It's a legal document, so that was very clear. And there was specifically an obligation to not review it in any sort of positive or negative way, but as I saw fit. Another example is I got a phone to review from Nokia about a year and a half ago. You can look it up on my blog. I didn't like the phone, and I said, here are the things I liked about the phone. Here are the things I didn't like about the phone. I sent the phone back.
Did you blog that?
Yeah. I did. I was very clear, and I said,
from them again.
No, actually, no, that's not the case. They actually gave me another phone recently, one of their Lumia 800 Windows phones, which is actually a great little phone to check out. But this previous phone that they have, it was laggy and it had some problems. And they hoped for a great review, but I gave it. It was fast on the network. It was it was light in my hand. It had a great display. But the software really needed work, and I was very clear. That's exactly what I heard, and I sent it back to them. And later on, they've reached out to me. They've invited me to events, and they've kept a relationship because they see I tell it the way it was.
As a lawyer, I'm interested. From a brand perspective, I think that's great that Samsung, had that paperwork ready, had you sign it. Mm-hmm. As a blogger, does it make you less likely to want to work with a company if you have to jump through all these hoops? Because that's what my clients always tell me. Oh, I don't want to have to put all this paperwork in front of the blogger. He's never going to want to sign it. He's never going to agree to it.
No.
I just wanted this to go as seamlessly as possible.
I've done. I did a white paper on endorsement of FTC rules as a ghostwriter for an agency which I can't name. And so I studied this kind of stuff, and I completely expect that. Now, let me also be clear. When I do this stuff, I do it on my personal blog. When I blog for any of the publications that I write for, and I wrote for several, I never do that stuff. And I'm very clear about that. I'm very clear with those companies that typically, if they're working with me personally, they're not going to get coverage in my column on Inc. or on if I write on Nashville or something like that, because I don't want to have to sort of backpedal and say I try to keep a a journalistic line on that kind of stuff. So I'm very clear that I keep them out of those things. I don't use blogs. In my Inc. column, I don't blog about clients I'm consulting with. I don't, even though I write a startup column and I'm consulting with several startups. I've used examples from startups and never named them. I never link back to them, even though some of them are really relevant to my column. I keep a very strict line, and I have a disclosure statement on my blog as well. I think it's really important. And the good bloggers, the bloggers that the agencies want to work with, are the ones that know these lines and that are willing to do these endorsement agreements and to play by the FTC rules. And the ones that aren't are probably the ones who don't want to work with, because they probably will sort of accept money and accept products for everything, and their stuff will look crazy Also, the other thing
That's
is
what I tell them.
you'll also see networks, high-quality networks like BlogHer, for example. If you're a woman that has a BlogHer blog, you're required by their rules to have a separate blog or a separate area of your blog that's very clearly denoted if you're doing a sponsorship kinds of thing. And they encourage you to do that and to have links to it, etc. But it's separate from your standard blog. And it's very clearly drawn lines because they want that high quality content. And then, if there's going to be an endorsement, they want it to be clearly to the side. And that's the best practices. If if the bloggers are not willing to take that hoop, jump through a hoop like that, or think about it, then they're probably better not to be worked with.
And I would add, in a regulated industry, where you're hiring a blogger and they're talking about something that could be considered health or medical or what have you,
sure.
There's probably an additional clause that even says, we're going to continue to monitor for a certain period
Don't
of
make
time
claims, right.
after you've done it. Don't make certain kinds of claims.
Right.
And if somebody says something in your comments that we may need to jump in and respond to it or what have you. So it's interesting that you're getting pushback from some of your clients, because I would just think that at this point the FTC guidance has been out there almost long enough, which is not very long, but still long enough, that it's got to become a standard with any quality blogger that they know they're going to have to, that they're going to want to work with. There's a set of blogger guidelines.
Well, the guidelines plus the enforcement action. I mean, they brought that enforcement action against Reverb very quickly to tell everybody this is what we meant.
Yeah.
All right. What about in the context of celebrities? Is there anything different in the analysis there?
Yeah, the example that comes to mind for me is Ashton Kutcher. I think got in trouble a little while ago. I don't remember the name of the company was. He's an investor in 10 million companies, but right. he would do a tweet that said, "Hey, this company's really great. Everyone should check it out." He has 1 million followers or 9 billion followers.
Airbnb.
Was it?
Airbnb.
Airbnb.
I don't know if that was the one. It was the one. All right. So yeah, and then it comes out later that he's a major investor in the company. The FTC put out some statement that they might pursue an action against Ashton Kutcher. They were thinking about it. It eventually went away, but he had to retweet later on that, just so everyone knows, I'm an investor in what is it? Airbnb. Yeah. So yeah, celebrities get into a lot of trouble in here, and as an attorney, when I'm signing up a celebrity to be a spokesperson for a campaign, we're working on provisions, social media provisions for our clients, and there's really two tactics they can take. Either you got to prove everything that your celebrity says before it goes out, and that really hinders the amount of social media presence that they're going to have online. They want them to tweet as much as possible, but from a brand perspective, at least you feel a little safer that you're going to know what they're going to say. Or you put in a right to take down whatever they said, and there's always a risk with that. Once something's out in the blogosphere, it's out there and you can't take it down, and people know about it. So again, it's a brand by brand perspective.
But I think just like you have expert bloggers, you have expert celebrities that are they are.
Does J&J hire celebrities?
Oh sure.
Really?
Yeah. You ever seen a Neutrogena commercial?
That's right.
But no. So I think there are some celebrities that are probably very sophisticated, and this is what they do. This is how they make half of their living now, or a bunch of their. And I think that there are others that are more green, and so that's another business decision in terms of whether you want to go with a celebrity that hasn't really done this before. And is giving you pushback on all the different terms and things you're putting in front of them, just like a blogger. I think it's pretty similar.
Yeah.
I mean, luckily for us, the celebrities who are plugging their work, it's pretty obvious that it's their work, and so they're excited about it, hopefully. Yeah. So we wouldn't normally hire another celebrity to talk about an artist's work.
So I'm not a celebrity though, and I don't even play one on the internet.
You seem so celebrity.
but yeah, I'm big on Twitter. But what I'll say is I would not sign up for, nor would I recommend my clients to sign up for anything where it dictated exactly what should be said, other than if I was Nike and I wanted someone to say just do it, and someone would say, do it justly or whatever. I mean, you don't want them to like mess with your trademark, right? But the whole point of having somebody endorse is that it should come from their voice. And if celebrities doesn't believe in whatever they're endorsing, or a blogger, Twitterer, or someone who you consider an influencer, or a regular person who you're working with on some sort of a campaign, can't put it into their own words, then don't work with them.
Yeah.
I mean, that's again, we go back to the credibility of, if I can't say, I think that the, and I actually do, and it's not because I have a Samsung thing sitting in front of me, I think that the effort that they're doing to try to get people to figure out which Olympic athletes are from their hometown and which Olympic athletes have same interests as them and same likes on Facebook and might be someone that you might want to follow. And hey, I had no idea that someone who was a skeet shooter was from my hometown, right? And this came about because they had someone in their offices who was a decathlete and no one knew it. And they're like, hey, we should just like let everybody know who their Olympic athletes are that they're connected to on Facebook. I thought that's a cool idea. I could get behind that. If I didn't think it was a cool idea, I wouldn't get behind it. And if I can't express something on my own terms, I won't get behind it. Now, that's my own integrity. I can't say that people don't just sell out, but you get better endorsement that way because people have ability to say it their own way, and you get that personal connection. Otherwise,
Right, but there are campaigns out there where the celebrity is hired for purposes of linking the name to the product, regardless of what the celebrity actually feels about the product.
And that's true.
And fed the content often. And the celebrity is going to insist on a right of approval over what it says at some point, but is it really from the heart? You don't know.
Mm-hmm. And what about consumers? Consumers can go to a brand's Facebook page and post comments of all kinds, some of which might be accurate, some of which might be inaccurate, some of which might be very favorable, so others might be complaints. What do you think are the best practices for dealing with consumers that use the brand's social media outlets?
Well, if it's our own social media outlet, I think you have much larger responsibility. If it's on our Facebook page or one of our websites or what have you, and somebody is writing a comment, I would imagine the argument would maybe have a little bit more of a responsibility. Someone says, I took your product and it cured my cancer, and we're talking about, something that
Neutrogena.
I don't, maybe I don't know. All kinds of things going on in R&D. But right. I mean, I wonder, perhaps not necessarily you have to take down the comment. Maybe you can be again a little tongue-in-cheek about it and say, "I'm glad you had a positive response to our product. That's not our normal reaction." Or maybe something is literally just so outrageous that it doesn't need that kind of clarification. I think again you can. I would say you have greater responsibility on your own sites, and then when you get to third-party sites, it sort of the responsibility diminishes a little bit.
I advise clients to have a policy on their Facebook page under their information tab. There's the info tab. Even with Timeline, there's still a pull down where you can find the info tab, and you put a policy, and you may link to a larger version of it. But basically, this is our Facebook page. You're welcome to it. We welcome comments and discussion. However, we do not allow and will take down without apology personal attacks, racial epithets, slander, spam, and define a bunch of those things, personal attacks against other users on the page and those kinds of trollings, multi-level marketing, links inappropriately put into the middle of comments. You have a list of things that are sort of very commonsensical. And I've seen even phrases like, if you wouldn't say it in my living room, it's not appropriate on my Facebook page. That's, there's a reasonable standard for discussion, right? And so it gives the brand or company a very clear way of saying, have someone say, hey, you took down my post. Yes, you called the CEO a, bleep, 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 right? If you have a disagreement with the CEO, you can say that, but you have to say it in a civil tone, and then we can actually have a discussion. But there's no, as the kids say, haters are going to hate, right? People are just going to, they're going to go at it, right? But at least have a way of beforehand setting that set of guidelines so that way you're within your rights and you're very clear as to what you're going to not allow.
But aren't your rights really dictated by Facebook's terms and conditions?
Well, there's Facebook terms and conditions, and then there's your page. Same thing with your Twitter account. You can have a link to a policy of what you'll respond to. Of course, people are always welcome to make their own blog and say, I hate name of brand. I won't insult any of your brands here. And in that place, they're pretty much on their own. And even if they're using your trademark, it probably is fair use of them, hating your whatever it is. But it's your opportunity to engage, try to make them happy, and make them a customer again. And or sometimes people are just going to be anti.
Right. Just some people that aren't.
Some people just not going to like you.
Yeah.
I think when we talk about brand pages, I'm less concerned about getting the upset consumer because we took down their offensive post. My bigger concerns, are whether there's one statement about the products, whether there's a competitive claim about the product or a competitor's product, whether that's accurate, and then also you have copyright potential claims, you have trademark claims, you have right of publicity potential claims. If on the American Express website, someone's continually posting about, I'll use my Kim Kardashian again, she's crazy enough to bring a claim, a right of publicity claim, and then the company has to worry about it. So what we often advise clients is if you're able to monitor it, which you should be monitoring your page at all, your homepage at all, look for those big things, references to celebrities, and get those down because those could be big claims.
I think competitor claims is a good call out too in terms of if somebody is even saying that your product is so much better than that competitor, and it's just really unrealistic what they're saying. If it's just mere puffery, yours is better, yours is great, whatever. But when they sort of overdo it and then they bring in a competitor's name, that's probably worthy of some kind of comment or a takedown of it.
It's tough when you're monitoring because Facebook does not make it that easy to see every single comment without extreme labor-intensive reading it. I mean, there are some tools that will tap into your Facebook comment stream, most of which cost a decent amount of money. There are a few that are free, but they're not intended for volume. And Facebook has not made it that easy for brands to look at every single comment nor respond to every single comment in a effective way, the way you might if you had a forum on your website or something where your comments can be moderated on a blog post or whatever. So it's certainly to your point, you try to find that kind of stuff, but there are stuff that you're going to miss.
Well, I mean, to some extent, though, what you can say to your brand is if you can't afford to do the moderating, the monitoring, then you can't afford to do the initiative, right? Because there's a lot of people out there who will say, I can just throw up a Facebook page. I can, they may think social media equals cheaper. Yeah. No. And I think that can be, our job to say to them, well, if you've budgeted X, make sure that budget X includes the resources you're going to need to do the moderation and the monitoring.
Although won't the traditional safe harbor principles apply to the Facebook page as well? So you're back to, if you're monitoring, then you're assuming the duty, but if you're not monitoring, you may not have a problem with some of the things you raised.
But you do have...
With some of them, you will have some safe harbors. Particularly the copyright might not be as big an issue.
Yeah. Right, but and there's some things that are attributable to Facebook. I mean, you can't necessarily know that someone's going to put up a copyrighted sort of picture.
Right, and if you have a takedown policy or something, contact us, and somebody can tell you that somebody posted something on your site, and you respond as quickly as you can, it's in a reasonable way, and get it down. Then that person's not likely to pursue it. There's practicality and there's legality as well.
Don't post any Sony music unless we've authorized it.
Well, you know who to call that.
That's true. That's true.
I wanted to loop back to the issue of employees, because employees can have their own Facebook or Twitter accounts, and they also might be making posts on brand, sponsored media. And I wanted to get a sense of what sort of guidance or something stricter than guidance, policies companies should provide to those employees about their use of the brand's own social media accounts or of their own?
Well, one thing I'll say is there are a lot of already, some companies make their policies public. And so I think you can search the internet a little bit and just sort of see what different types of companies have said. I think Coca-Cola's is public.
Intel, IBM, both great public policies.
Yeah, and you can
SAP.
sort of see, where, based on what type of business you have and what type of employees you have, and whether you're a highly regulated industry, a moderately regulated industry, what have you, you can see if something that's already, someone else has already spent money with their lawyers to write, might be adaptable to you. It's a tough struggle. I mean, as I said at the beginning, I struggle with it personally. I find myself self-censoring all the time, and it's just about education and being realistic.
From a consulting perspective, if you're not helping your employees to properly endorse your products and to be out there and sharing what it is that they do and the company that they work for, then you're not doing a duty to your stakeholders, your shareholders, whomever, right? Your employees, if they really like your company, should like your company. And obviously you have to work with your legal team, and obviously if you're in a regulated industry, you have to be very careful about that. But just like you want your customers to talk positively about you, I would hope that you would want your employees to talk positively about you with the proper disclosure, with the proper training and discussion, and not to be, to be clear, you're not speaking on behalf of the company, you're speaking on behalf of you. But hey, if I work for Coke, for example, you're not going to see me drinking another brand at a party. And in the same way, you won't see me drinking another brand on my Facebook page. And I would hope that would be, something that the marketing and legal teams would spend some time working out, and that's the kind of thing that we try to do.
There's a balance between your personal Facebook page,
right,
where you're really communicating with your friends who know who you are, or hopefully they're friends, or there's some kind of description of who you are on that page. I think it's a little different when you're commenting on the company page, because that's public.
Sure, and it's we're talking a lot about Facebook. We mentioned a little bit about Twitter, but there's Pinterest, there's LinkedIn groups, there are any number of networks. When you're talking about music, there are I could you rattle off a list of music networks and stuff like that. Yeah, I mean you should. One of the things you go back to when you create policy for your employees is to say, hey, when you put up a policy, when you put up a profile on a network, if it's going to be something where you're going to be talking about stuff related to the business of the company, you can claim, I'm an employee of this company, I speak for myself, or I'm an employee of this company, I'm a spokesperson for this company. And be clear. That's going to help you stay out of trouble. And of course, if those people are going to be official voices of your company, you better have given them some training.
I will say though, apropos of what you're talking about, I do think you have to be careful though. I agree you want your employees to like your products, but you really shouldn't be pressuring your employees to like your products online. And in that regard, we've been cognizant of this for a while. So one of the things I do, we get a lot of interns at Sony Music, and so every intern orientation I come down for about 10 minutes and show them some social media do's and don'ts, and it's sort of what I was talking about earlier, but specific things to remind them of, because of course in a company like ours, it's those interns who may be asked to do something like that, I literally say to these interns, and if anything happens and you feel uncomfortable about anything, call me, because I can talk to whoever it is you may have gotten some
no insult to Sony Music or the policy, but if you're talking about stuff that's related to your brand, your image, your corporate communications, you have no business putting an intern in charge of that at all. And as a company, you're irresponsible for doing such a thing. In the same way that you probably wouldn't have your intern draw up your advertising for the New York Times or shoot your TV commercial with their flip cam, if the person doesn't know your brand voice, they don't know your brand book, they don't know the things that you're going to say, they don't necessarily know how to respond when someone asks a difficult question about the company, then they need supervision and they need guidance. In the same, this is an open telephone line to your CEO's office, and if you're a larger company, an open line to your stockholders. Don't put it in the hands of a 21-year-old who may come out of college with a great Twitter following and a great Facebook account, but zero sense of marketing or branding or communications. you know, it's a recipe for disaster, as so many companies have found out. Just as a point, yesterday there was a huge, horrible earthquake in Indonesia, and on the way out of that, the tweet from KFC Thailand was, you can go back home now, keep watching the earthquake news, and don't forget to pick up some KFC. I will bet you that was someone's intern. And they already had to apologize, and Yum Brands had already apologized and pulled that in order to sort of, you know, apologize to a public that's been devastated by an 8.6 earthquake. You know, I can list examples like that all night long. There was a Nestle dust up on their Facebook page, and the intern that was in charge of it started arguing with customers over what was effectively a public policy issue of did Nestle or did they not, you know, endorse cutting down of certain trees for palm oil in a protected habitat. You know, that's the kind of stuff that your investor relations people handle, not your intern. I'll get off my lecture now.
I just want to throw one other thing out there, sort of related to this, and it's a separate legal issue, but there's a case pending right now where the Twitter account that the company used to do all the company tweeting, they didn't own it. The employee owned it. And so when the employee was let go, the employee controlled that account, and the company's trying to get it back. But it's a big problem because everyone identifies that account with the brand. And that's something that should have been thought about at the beginning of that process, and or the day the employee was gone, dealt with. So.
Right, and we have that exact same issue too. We have marketing people that move around and what have you, and you know, you should think about setting up some kind of policy where if you're going to open a Twitter handle for a brand, it has to be with a company email address that your IT people could somehow get into at some point if the person left. With, you know, and you have to, someone has to know what that username and password are, or a special email address has to be set up just for the account, and so yeah, that is a real issue. It's control. When
you talk about like a great example of that, there's the Dell folks who tweet for Dell is Lionel at Dell, Richard at Dell, Susan at Dell, and a bunch of other people who I met recently at Dell, and their names are all clearly in that thing. Now, I forget whether their policy is that they can leave, but they have to change the name of their handle, or whether the company owns the handle. But either way, that person, if they were to leave, would no longer be Joe at Dell. They'd be Joe Schmo, and they would no longer be associated with Dell, and you know, obviously would not have the access to their resources. And that's a really simple and easy policy to set up with certain software that you use with Twitter specifically. Twitter has actually set up in their API so that companies can have a sign-in and then permission someone to use that account, and that person never has the password, they only have a token, and the token can be revoked. So I know specifically the software CoTweet is set up like that, where a company can set up an account for an employee that the employee is only given a token, but the account is specifically owned by the company. And you know, it's worthwhile setting that kind of thing up. Additionally, a client actually just emailed me recently saying the person who used to manage our Facebook left. We don't have access to it anymore. You were our consultant. Do you still have access to it? And I said, actually, yes, they never removed me. I'd be happy to add you back in. Just pay me the last payment you owe. Which they did by wire the next day, and I immediately turned the account up. No, it's as a consultant, I would never have denied it to them. But it was it's worthwhile.
It's funny because it's not that new of an issue if you think about when domain names were first, internet websites where you would hire a company to create the internet website for you, and they owned the site and they hold it hostage. And,
you
don't want to do that. All kinds of things when you moved on. So it's not really a new concept. It's just a new medium. It's funny how things come.
When you make an agency agreement, do you make sure that the agencies disclaim any rights to any of the social accounts that they may create for a company?
Oh yeah.
Okay.
But from a brand perspective, if I'm doing it on that side, of course, if I'm on the other side.
Sure. But I mean, if you're hiring consultants, if you're hiring someone like me, you're going to put that in the agreement, and I'm going to sign it because it's the right thing to do, right? You're going to make sure that you own the accounts relating to your name. Of course, there's trademark things, stuff like that, but you don't want to spend like 30 days in trying to find Alex over at Twitter as the legal counsel and try to get him to give you back the name. You don't want to spend the time doing that.
The other thing I wonder about with the with Dell's, say Christine takes over Joe's handle,
Right.
They now being misleading. And Christine's the one tweeting out all Joe's concepts.
Well, yeah.
But I mean, it's a crazy concept.
So Comcast and Citibank have both done this kind of stuff where the accounts are clearly, and I've heard them speak on this policy. It's not my thing, so take this for what it's worth. But when I heard them talk about this, they said, we keep the employee accounts names, and if so and so leaves, a new employee comes, we'll change the name to that person, but they're still tweeting for the company. And so it's not expected you're following this person, you're following this company account, and you now have a new real person to deal with, and we use people's real names. But and I thought that was a reasonable policy as well, because they have to protect that, and especially they may have a history in the account of previous tweets that they've done or direct messages to customers with customer information, and you want to make sure that that belongs to the company specifically.
Well, the handle itself could be a little more generic, but you can still give a name associated with the person who's tweeting about it.
The other thing I was going to say about social media policies is, if you ask any of the attorneys at the table, should you have a social media policy for your brand or your agency or whatever, then your company will definitely say, yeah, you should have a social media policy, but you have to think about what is the purpose behind that policy. If you just want that because you want to be protected in some way, if the FTC comes after you or some agency comes after you, they say that your social media policies, your employees were doing all these awful things, like, whoa, we had a social media policy. That's one thing. You can go to an attorney and they'll draft up some social media policy for you. But what the more sophisticated brands are really thinking about is, what do we actually want people to say? What do we want people to do, and what do we want them not to do? And then that's when you really have the interesting discussions with your attorneys that can help you draft, what you mean to have people do.
So there are multiple different kinds of policies from a business perspective. There's the policy for what you have your general employees do or don't do on their sites, what you do or don't have their employees do on your sites, what you have executives do or don't do, and that sort of goes with your whole communications and policy. And then there's the policy for how people act on your website, or like a privacy policy, as well as a social policy if you have comments enabled. And then there's the policies towards your Facebook and Twitter presences and stuff like that. So there's multiple sort of different ways of cutting this and thinking about it that you kind of have to go through, and do spend time with intelligent legal counsel who's done this before. Find somebody who has done this before, so you understand that, because it's worth knowing about it before you have to fix a Band-Aid at the end.
Right. One last topic before we move on to questions. I was just wondering, user-generated content is it can be a significant part of a brand's campaign. If there's consumers posting things on the Facebook page that the brand would like to use in its own marketing, or if a brand is creating a campaign where it's inviting users to submit certain materials. We don't have too much time to go into this in too much depth, but what are the risks that worry you the most with those types of...
Be careful what you wish for.
Chevy did a Tahoe thing where they let people put their own captions in between clips of the cars and different environments, desert and winter and this and that, and people put something like, Chevy Tahoe, 12 miles per gallon, maybe you should buy something else. So, and those videos automatically got posted to their site. And to their credit, they left it up and said, hey, we messed up, we shouldn't have done it this way. We won't do a contest like this again. So yeah, be careful, sort of what you're asking for. But if you have, I'm not going to speak to the legalities of it, but certainly if you have fans that are going to, put out content that shows how much they love your brand, by all means, find a way to use that.
And I think of course, with any sort of promotion, you want to have your standard rules and be able to link to them as much as possible. But on a basic level, you got to be concerned about what you're asking people to do. As part of your contest, create a video that looks exactly like, Rebel Without a Cause, and have someone that looks like James Dean in it, and post it on our website. And then, whoa, you got all these sorts of issues that you're going to have to worry about. So you don't want to encourage the infringement, but you might be under, as we talked about some before, there might be some safe harbor protections for you depending on what you're asking consumers to do.
One of our big challenges, we're doing this a lot now, is asking users to create videos with various artists' music. And my big challenge is, if you're just having it on the site, I don't have the same problem I have until it really takes off and then people want to use it as a commercial product. And then I have real issues around all the sign-offs locating these users and making sure we have the right to use their image, because we're now going to try to make money off of it. And it's become a real issue for us because some of them have been really good.
Right, there was that wedding dance one that everybody loved, right? Chris Brown, right? That was a Sony music artist, right? And that got millions of views, and they were on Today Show. You guys probably didn't mind that much.
Well, that one we certainly didn't mind. But yeah,
if I did it for my kid's birthday, I'd get a takedown notice.
We've taken both sides of those issues. Johnson, do you user-generated content?
Absolutely, yes. And it's a struggle in terms of how you word the contest, or you don't necessarily need to own everything that somebody submits. You just need to have perhaps the right kind of license to it. You got to think about what's going to be in it and pre-moderation of it, depending on what it is and what kind of. And also, you have to. I think the brand, we've let our brands do lots of experimenting on different things. You got to think about whether you have users that would want to put a lot of time and effort into your particular contest. And I mean, we have had, wonderful successes and absolute failures.
Sure, right.
And I think that's great. I think I actually, what do they say, fail fast and move on, or whatever it is.
Right.
But, it's very funny. I mean, I don't know how many people are going to want to watch a video of you swirling mouthwash and spitting it into the sink, but, in different ways. But, one person entered that contest. And, but I think there was, so anyway, I think that's the thing about user-generated content. It depends. You have to know your audience, know that you have the fan base that is going to actually put the time and effort into the submission that you're looking for. As you said, to get to work with Sony Music and make a really cool video, I can imagine people would take a significant amount of time and effort. And the other thing is, though, you have to realize, and that's, again, with these Chevy commercials, if someone's going to take a lot of time and effort to do something, and then you reject it if you're doing a contest through YouTube, they're just going to post it anyway on YouTube. It's a little different for Sony Music, perhaps, because you can probably get it pulled down. But if someone's put a lot of time and effort into something and you reject it, it's going to go. They're going to find another way to post it anyway. And say, look what X company didn't. This was too racy for their contest, but I want you to see it.
By the way, Facebook has really clear guidelines on what you can and can't do as contests. First thing is you have to do an app. Second thing is you can't make liking like a particular picture or a particular item of content, whatever, a requirement for being part of the contest. So just
you can't automatically.
You can't automatically. There's a whole bunch of things. I mean, you can make somebody get to your contest by liking your page and stuff like that, but there's usually an alternate way to enter it.
And there are a lot of
there's a huge amount of terms and conditions. Spend the time to talk to somebody who understands contests. Don't just say, hey, we're gonna everyone submit a picture and whoever gets the most likes wins. And by the way, you have to like our brand because you will probably if somebody complains to Facebook, you can get your page suspended.
Right. And Facebook is not, from our experience, they're not monitoring this that closely. But once they do, once you violated the terms and conditions.
And once you get on their radar,
try getting a page back once it's been put into Facebook jail. I will tell you, even
Facebook jail.
One of my clients had created a second page for a second brand and somehow managed to migrate their users over to it by accident, which was an option or something like that. It took me 3 months to find somebody at Facebook who would help them put it back the way it was. I kid you not. Unless you're buying a lot of ads, and I'm putting them down, but they have 880 million users. I'm sorry, but your call will be answered in the order of things received.
Great, and that really concludes our roundtable discussion. So at this time, we can open up for questions from the audience. With the pink scarf.
So I thought you guys gave a lot of good information of all the kind of clear, bright lines as they relate to what brands can do and what brands can do with their employees and employee posting. I'm curious if you have any advice or thoughts on how brands are limited, not just by best practices, but legally limited in terms of taking down comments that they don't like, either from their Facebook page or some other platform that they are renting and not owning.
Okay, so the question is, how are brands limited in terms of taking down content?
Well, there's the First Amendment, and that is a very important tool, both for pro and
Turn the mic towards you.
it's not listening. So I mean, you have to be careful, and you have to understand that legitimate criticism may be permitted. Doesn't necessarily mean that you have to let that person continue to criticize over and over and over and over again on your site. And then there are people that we were talking earlier as the haters. And each of these social media tools have ways of blocking people that are inappropriate. And I think what we do is we do have some general terms and conditions, like we were talking about before, that give us the ability, give us something we can point to that says you violated our terms and conditions. We're not going to allow that that comment to continue, or you give somebody 2 strikes or 3 strikes and then they're out. And on other third-party sites, if somebody is infringing your copyright or infringing your trademark, that's legitimate grounds to go after somebody. It's a case by. The problem is it's really case by case and very context specific.
And remember, if you're going to take down anything, you should take down the whole thing. Don't censor it, just take it down.
I moderate a group on Facebook for Social Media Club, which is another nonprofit, somewhat similar to, for the social media industry, to New York Tech for the IT industry. We have a group on Facebook. I have a 1 strike and you're out policy, because it's a private group and you have to join it. If you join it and the first thing you do is put up multi-level marketing post, you're out, you're banned, and that's it. It's very simple.
Right. And I would get going.
So I guess I was thinking more about, sorry, thank you. Just to use a kind of bright line example, can people go on the Coke page and say, Coke stinks, I love Pepsi? Or forget even the Coke stinks part, just, I love Pepsi, Pepsi's great. And does Coke have any legal, what are the legal implications? Obviously Coke doesn't want to see that on their page, but are there, and it would be best practices to leave it up.
I guarantee it happens multiple times every day.
Yeah, those sorts of issues really end up tending more on the PR side than the legal side. There's really, you have your site, that Coke's Facebook page or whatever their page, their Pinterest page, is really an advertising. It's their own website that they own, that they can advertise on, that they use as their own channel. It's just like Coke's website. If someone wants to make a comment on that, they're free to make a comment, but from Coke's perspective, we have our terms and conditions. We can take anything down we want. We can do anything we want with it. The questions, they usually, when they get to us, are do we want to take it down? What is it going to say? What does it say in the community if we're not letting people speak freely on our website? But from a legal perspective, there's usually, unless you have, a defamation issue, an issue about copyright infringement or trademark infringement, it usually is more of a PR concern.
Well, and if you have good fans, they'll come to your defense first, but before.
And that might be better.
And that's almost better, right? You'll have, somebody is on the Coke page and they say, I love Pepsi. I will bet there will be 25, before you can blink, responses. Well, get off this page. I mean, it's a very self-moderating community. Don't you find?
Definitely find
that. And we've found
they get very angry.
Yeah. Well, but no, and sometimes people will. You can actually almost see the shift in the comments, where you first have the yeah, me too's, and then all of a sudden you have the wave of the people coming back and saying, bring this back to reality, and then it sort of starts to balance it out. But you can watch it. It's like a social media crisis happening in the comments. I see it in YouTube comments all the time, and so that's my.
And that's the reason why you cultivate your fans. You respond to them when you ask your questions. Because if you don't, then when those kinds of sort of negative things come up, there's no one there to defend you. But if you've treated your fans correctly, then they will come to your aid exactly like you were saying.
And that happens all the time with us because they literally are fans. So they're so tied to that artist that they see things happening and they're out there.
Well, and you can turn somebody from a hater to at least neutral. You know, somebody's on your Facebook page and they say, this page is so stupid, I can't get the coupon thing to work or whatever. If the next minute later there's a reply, I'm so sorry, you know, that you're having trouble. Here's my phone number, call me, I'll send you a paper coupon. You know, and you know, oh, thanks. You know, it's just, you can really, if you've got good, robust, you know, monitoring of your own page, then you can really nip these things in the bud.
Squeeze in a few more. The gentleman with the white and blue striped shirt.
I just want to ask about the celebrity endorsement question. It seems to me that it's pretty clear if people are getting paid that they have to disclose it in some fashion. But I was sitting here looking, and unfortunately Kim Kardashian's really, you know, taking it on the chin tonight. But I was looking at her Twitter feed, and she's got, you know, half a dozen things on here, which I assume, because she's talking about there's shoes and there's pants, and these things are so wonderful. And then she actually even made a reference to some retailer, I don't even remember. She didn't disclose any of her tweets.
Right. Well,
pound paid or pound spawned or whatever. So I'm just wondering, and that seems to be that's the case, that the law seems to be pretty clear, but that no one's really doing that, or is it just that's a sample of one that's unfair?
A lot of brands are not doing it. A lot of celebrities are not doing it. But also, when you get to a certain level of celebrity, it's all about what the general audience is going to understand from a tweet. If Kim Kardashian is tweeting about, you know, whatever, jewelry or something, people, the general public might generally understand now that, oh, she's obviously a paid endorser. It's different with a celebrity than with Joe Schmo off the street. So at this point, maybe Kim Kardashian, or at least the brands have gotten comfortable that Kim Kardashian's at a level where anything she says about a brand, people will understand that there's a material connection. That could be a brand perspective. I'm not saying I would advise a brand to take that position, but they might be getting there.
If it was like Tina Fey or whatever, who was more low profile or something like that, would, you know, you would say,
yeah, the guidelines are pretty clear that you should be making some sort of disclosure, whether it's with the hashtag spons that we talked about or something, you know, less obvious. But yeah, the guidelines are pretty clear about it.
Yeah, if a reasonable consumer could think that was actually that person's, you know, personal opinion.
I think she really wants the baby seahorses. I don't think that she's endorsing that.
Yeah, she might not be an endorser of it. She might just actually like it.
Yeah. In the back of the room, the young lady. Yeah.
Hi, everyone. I'm actually from Comply, so thank you for the mention. And if anyone has any questions, I just wanted to clarify something, and then I have a question, actually. Comply is a disclosure solution for social media, but we also offer integrated monitoring solutions. Thank you. Anyway, but my question is this. Ambassador programs. We're talking to a lot of brands who, you know, are suggesting ambassador programs?
Ambassador programs.
Okay.
How are you guys advising your clients on ambassador programs?
Is that an ambassador that's an internal ambassador, or you're hiring someone to be an ambassador?
No, we're seeing a growing universe of influencers that are being engaged in social media. So there used to be a clear traditional influencer that is a blogger, you know, who has a great deal of influence, and so you hire them or you pay them or you incent them. But more and more brands are actually starting to create influencer networks that are more, they're called bottom of the pyramid influence. So it's a lot of people with a little bit of audience, but they're more fans or passionate about your brand. And you're not outright paying them, but you're organizing them, you're recruiting them. Maybe you're giving them little things here and there. How are you guys advising?
Yeah, I was going to say
Can you repeat the question?
there are these brand ambassadors that brands are not necessarily paying any money, paying them to organize events for brands. But I think the question is whether the brand, how we're advising brands to actually disclose that those brand ambassadors have some sort of connection with them. And what I was going to say that, you know, a material connection doesn't necessarily have to be money. It could be any sort of connection between the brand. So whatever that connection is, if it's not immediately apparent, we advise our clients, and whether if our clients are the ambassadors also, we advise them to advise whoever they're speaking to, whether it's at a conference or whether it's in social media, that, hey, I have this connection with my brand. And it's really the same as any blogger advice we would give, and that's generally the tactic we've been taking.
At what point does it rise to the level of a connection? Because, if you're a company and you're taking care of your fans by, if someone tweets you, you respond to them immediately, and then they tweet you back and you start having a conversation, you give them information about your company, are you making them an ambassador, or are you just treating a customer really well? Where's the line on that? Is I guess a good question.
Yeah.
It's a tough question too, and we get that. I get that question sometimes where, we've got somebody on our page that on their own volition is just making all these wonderful comments and just loves the brand so much, and the brand really wants to do something for that person, like give them a gift card or give them a coupon or whatever. And I think what you say, the conversation you have with the person from the brand is, but you might sort of turn that person from an authentic fan to somebody who now has to disclose that they're being compensated or otherwise endorsed.
I think the key line is, when did you get that opinion? Was it before they were promised or incentivized to say it, or was it after? And once you start incentivizing them with something, then you've changed the landscape.
All right, one last question from...
I actually have two questions, one specific and one general. The specific one is, how effective, you talked about it, but I'm still not clear, of blanket licenses. For instance, if a blogger has one link on their blog site. One link on their blog site to say, well, I think I can continue. One link on their blog site to say, here are all the people who I've been compensated by, or if a brand has, one disclaimer on their, or a thing on their site saying, this is our policy, and everybody else should follow it. That's my specific question. What does the FTC say about that? And two, just a general question about, where does this run into First Amendment freedom of speech?
On the first issue, the FTC says there's no one-size-fits-all approach. So unfortunately, I'd love to give you a specific answer to the specific question, but it depends on what the blogger is saying. It depends on, I'm sure you handle it differently for different clients. So it depends on what exactly you're doing, what the client wants, what you're given exactly. Yeah, so for some blogs it might be okay just to have that one disclaimer at the bottom. Hey, I was paid by X and Y. Any brand mentioned, I was paid by them brand, or I was given a product. For a lot of other blogs, you got to be a lot more specific. And the FTC specifically says it's a case-by-case approach, and it's got to meet the criteria of what you've gotten.
First Amendment.
First Amendment.
Well, it's commercial speech, so I'm not sure there's a real First Amendment issue. You mean your First Amendment right?
It's my First Amendment right to say what the hell I like.
On your blog page,
yes, on your blog page,
you have the absolute right to say whatever you want, and unless you're I'm not going to be a lawyer, but unless you're stealing people's stuff to do it with, I think you're probably okay. Right?
Yeah, I mean, brands might go after you if you use my trademark, in a way I'm not comfortable with, or if you defame me.
The FTC?
The FTC, that's probably not going to be in the FTC's
Not unless you're getting paid for saying those things, or some other.
If I'm getting paid, I don't have First Amendment rights to say what the hell I like.
No, you just have to disclose that it's more about if you're making positive comments, then you really need to disclose that you received something.
What if you're getting paid to make negative comments? I hate that. So
that's bad. That's bad business to pay someone to make negative comments. But
that's bad business.
Thank you, everyone. We've run out of time for now, but thanks to all of our panelists.